Good afternoon, everyone. This is Edward Gripaldo, criminology student of ICCT, section MO25. This video will serve as my blindfold activity for chapter 4 with the title of Accusation of Jurisdiction of Court for the subject of criminal procedure and court testimony. How the court acquires jurisdiction over the person of the accused. Define each. The court acquires jurisdiction over the person of the accused upon voluntary submission of the person of the accused to the jurisdiction of the court by posting of bail, by arrest of the accused. 1. Voluntary submission. The accused recognizes the jurisdiction of the court over his person and will abide by the orders and directives of the court until the final disposition of the case. Usually, voluntary submission is only required by the court in cases the information does not require the posting of or in light offenses, which is covered by the rules of summary procedure. 2. Bail. Bail is the security given for the release of a person in custody of the law, furnished by him or by the bondsman, guarantee his appearance before any court as required under condition herein upper specified. Bail will be given and the corporate surety, property bond, cash deposit, and or recognizance under section 1 rule 114. Number 2, what are forms, kinds of bail? Defined each. Kinds of form of bail. A. Cash bail. Cash bail is a sum of money and amount designated in an order fixing bail posted by the accused or by the another person on his behalf with a court or other authorized public officer upon condition such money shall be forfeited if the accused does not comply with a directive upward requiring his attendance at the criminal action or proceeding involved and does not otherwise render himself amenable to the orders and process of the court. B. Corporate surety issued by a professional bondsman. That is one who habitually engage in the business of furnishing bonds in civil actions, or persons arrested, detained, or for prosecution. C. Recognizance is a contract between the sureties and the state, or the production of the principal at the required bond. It is an obligation of record entered into the some ports magistrates duly authorized to take in, with the condition to do so, to do some particular act. The most usual condition in criminal cases being the appearance of the accused or trial. The signature of the accused is not required as an indispensable condition for the validity of the undertaking under recognizance, except perhaps when he himself is the recognizer. The property bond is an undertaking constitute as affiliate bond on the real property given as security for the amount of the bail. Number 3. When bail is a matter of right. A. Before or after conviction by the Metropolitan Trial Court, Municipal Trial Court, Municipal Trial Court in cities, Municipal Circuit Trial Court, before conviction, before conviction, the trial court of an offense not punishable by death, reclusion perpetua, or life imprisonment. Number 4. When bail is a matter of discretion. Upon conviction by the regional trial court or of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice of appeal, provided it as not transmitted by the original record to the appellate court. Number 5. What are the place where bill may be filed? Place A. Bail in amount of with the court or the case is herein, or the in absence of an availability of the judge thereof, with any regional judge, any regional trial judge, metropolitan trial judge, municipal trial judge, or municipal circuit judge in the province, city, or municipality if the accused is arrested in a province, city, or municipality other than where the case is tried in, maybe also be filed with any regional trial court of the same place of no judge thereof is available, with any metropolitan trial judge, municipal trial judge, or municipal circuit trial judge therein. B. Where the grant of bail is a matter of discretion, or the accused seek to be released on recognizance. The application may only be filed in the court where the case is indeed, whether on preliminary investigation, trial for appeal. Any person in custody who is not yet charged in court may apply for bail with any court in the province, city, or municipality or he is held. Number 6. When warrant of arrest may issue by the regional trial court within 10 days from the filing of the complaint or information, the judge shall be personally evaluate the resolution of the prosecutor. In each support evidence, he may immediately dismiss the case with the evidence on record clearly face the established probable of cause. If he find the probable cause, he shall issue a warrant of arrest or a commitment order. The accused has already been arrested pursuant to warrant issued by the judge who conducted the preliminary investigation, or when the complaint or information it was filed pursuant for section 7 of this rule. In case of doubt of the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, in the issue must be resolved with the court within 30 days from the filing of the complaint of information by the municipal trial court when required pursuant to the second paragraph of section of this rule, the preliminary investigation of cases falling under the original jurisdiction of the Metropolitan Trial Court, Municipal Trial Court. In cities, Municipal Trial Court or Municipal Circuit Trial Court may be conducted by either judge or prosecutor. When conducted by the prosecutor, the procedure or the issuance of a warrant of arrest by the judge shall be covered by paragraph of this section. When the investigation is conducted by the judge himself, he shall follow the procedure provided in section 3 of this rule. In his finding, recommendation are affirmed by the provincial or city prosecutor or the ombudsman of his deputy. Corresponding information is filed. He shall issue a warrant of arrest. However, while waiting for the conclusion of investigation, the judge may issue a warrant of arrest if he finds, after an examination and writing and under oath of the complainant in his witness in the form of sergeant question and answer, that probable cause exists and that there is necessity of placing the respondent under immediate custody in order not to frustrate the ends of justice. When warrant of arrest is not necessary, a warrant of arrest shall not issue it if the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with paragraph B of this section, or if the complaint or information was filed pursuant to section 7 of this rule, or if the offense penalized by fine only, the court shall deem proceed and the exercise of original jurisdiction. Number 7. What are remedies after the court jurisdiction? After the court acquires jurisdiction to the person of the accused, there are numerous remedies. A. Quashal of information. B. Assailing the validity or legality of the warrant of arrest issued against him. C. Assailing or questioning the regularity or absence of preliminary investigation. D. Quashal of the search warrant and oppression of evidence obtained, and or E. Suspension of proceeding by reason of prejudicial question. F. Motion for file motion for G. Motion for production and inspection of material evidence and possession of prosecution. Thank you for watching and have a nice day.